Hello everyone, this is Dhananjay Sharma and you are watching World Legal Help Organization. In today's video, we are going to discuss about a very popular term in the society, that is will. And in this regard, we will discuss what is a will, who can execute a will, how a will is executed, what kind of property can be given in a will, when a will comes into force, and about the revocation of will. So first of all, let's discuss about the definition of will. A will is a legal declaration of the intention of the testator, that is the person who is executing a will, with respect to his property which he desires to come into effect after his death. It is the settled principle of law that if a person dies intestate, that is without executing a will, then his property is disposed of as per the rules of succession. But in case he executes a will before his death, then after his death, his property is disposed of in favor of the person in whose favor the will is executed as per the provisions of will. So we can say that by way of will, he can name the persons in whose favor his property is to be disposed of after his death. Now the second question arises is who can execute a will? Any person who has attained the age of 18 years, that is any person who is a major and who is a person of sound mind can execute a will. A person, if he is suffering from a physical disability is of no importance at the time of execution of will. Even if he is suffering from a physical disability, he can execute a will because he is a person of sound mind, and in that case he can execute a will. Now the third point is to be considered is what kind of property can be disposed of by way of will. So in order to execute a will, a person can dispose of both his movable and immovable property. However, the point to be noted is that the property must be self-acquired or either that property must be inherited by way of succession. If both the cases are not there, then in that case, that property cannot be disposed of by way of execution of will. Now the second thing which comes into force or which comes into mind of every person is how a will is executed. It is often said that in order to execute a will, we have to go to the court and hire a lawyer, and by way of court and by hiring a lawyer, we execute a will. However, that is not the case. Even on a simple piece of paper, without the help of any lawyer, a will can be executed. It can be either typed or it can be handwritten. The most important thing that a will must contain, it is the contents of or the wish of the testator, and it must have the signature or the thumb impression of the testator. Moreover, it must be attested by two witnesses by way of signature of the witnesses over the will. However, the point to be noted here is that a person in whose favor the will is executed, he cannot be a witness at the time of execution of the will. Moreover, a minor person or a person of unsound mind cannot be a witness to the will. Now the next question arises about the revocation of a will. Whether a will which has been executed can be revoked. So the answer is yes, it can be. A will can be revoked n number of times as per the wish or as per the desire of the testator. However, it must be stated, it must be clearly mentioned in the new will prepared after the revocation of the earlier will that the earlier will has been revoked, and in this case the last will which has been prepared, that shall be considered to be the final will and that shall have the final effect in case of any dispute. The next question arises is regarding the registration of the will. That is whether it is mandatory to get a will registered or not. As per the provisions of the Indian Registration Act, it is not mandatory to get a will registered. Still, it is preferred by many people to get a will registered so that it becomes more authentic, and in case of any dispute, the question of execution of will does not arise since it was executed before the competent authority. Now the last question arises is regarding how and when a will shall come into force. So after a will is executed by the testator, after his death, the will shall come into force, and the person in whose favor the property has been transferred, he shall become the ultimate owner of the property. However, if the person in whose favor the property is executed or the will is executed, he dies before the death of the testator, then in that case the will shall stand cancelled. Also, if the testator as well as the person in whose favor the will has been executed both die at the same time, in that case also the will shall stand cancelled and the property shall be disposed of or the property shall be divided as per the general rules of succession. So that was all with regard to the will and as the provisions with regard to the will. Hope you liked the video. Thank you very much.